Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we are going to talk about the breaking news that came out last night in Dobbs versus Jackson and the leaked draft opinion overturning Roe versus Wade. So hope you find this video helpful. If you do, please subscribe to the channel, like the video, hit the notification bell, and I just want to jump right in. So news broke by Politico last night that a draft of an opinion from Dobbs versus Jackson written by Justice Alito was leaked by someone inside the court, showing that the Supreme Court of the United States intends to overturn Roe versus Wade. Now, that case was published way back in 1973 and was reaffirmed by Planned Parenthood versus Casey in the 90s. And there have been multiple attempts to have it readdressed by the conservatives in the court, and it has withstood over the last several decades. But if this draft opinion is correct, there will no longer be a constitutionally protected right to have an abortion in the United States of America. So I have actually downloaded and printed off the entire 92-page opinion draft and have read it extensively. You got highlights and all that stuff. So I'm not going to read the whole opinion to you because this would be a 2-hour video, but I just want to point out some things to see what the court's reasoning might be, what Justice Alito's arguments are, and what it means for the right to have an abortion going forward. At the very beginning of the opinion, he says, for the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. Then in 1973, this court decided Roe v. Wade. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. Right out of the gate, you can see that there is going to be a historical argument here, and that it's going to be determined based in part on what the law has been previous to the 1973 decision in Roe v. Wade. On page 2 of the opinion, Alito notes that the opinion in Roe versus Wade concluded with a number of set rules, much like those that might be found in a statute enacted by a legislature. So in other words, he's going to be likely he is telegraphing that the court was engaging in judicial activism, in judicial legislation, rather than leaving the case to the legislature to decide. Under Roe versus Wade, the Supreme Court laid out a 3-trimester plan and rooted its decision based on the viability of a fetus as to whether it is a person or a potential person. And this 3-trimester scheme gave the right to the fetus more rights in some aspects, and then in the other aspects of the trimester, the right to the protection of the woman was higher. But what this opinion doesn't address in detail, and what most people don't recognize, is that Jane v. Doe, which was the companion case, actually is the case that made abortion widespread, because that case decided that the mental health of the mother, the psychological issues, constituted a health issue such that anybody who wanted an abortion for any reason would be able to have the right to have one. But because it relied on Roe v. Wade, this opinion also overturns that decision as well. But a lot of people don't know that. That's the opinion that really made abortion widespread, because it took this 3-trimester aspect of Roe v. Wade and turned it on its head and essentially made it viable for any woman to be able to get an abortion at any time in any of the trimesters. So this case will also overturn Jane v. Roe as well. Alito then addresses the decision of Planned Parenthood versus Casey from 1992, and the court did not establish a majority opinion. It was actually a plurality opinion, which means that there were more justices that joined the plurality opinion than didn't, but it wasn't a majority. There weren't 5 justices that joined. What happened is there were several concurrences, several dissents, but there was one opinion that was written and was decided on and accepted by a plurality of the court. And so Alito notes that and says that there were 3 different views by the Supreme Court in Planned Parenthood versus Casey. One of those views was that Roe shouldn't be changed in any way. Another view was that Roe should be completely changed, and then another one believed that there needed to be some tweaks. And so there were three different ways that the court was dealing with it. And then it said in the opinion that Roe's reasoning was wrong. So even in the opinion upholding Roe versus Wade, they noted that the reasoning in Roe v. Wade was defective. And Alito points that out. But the rule that replaced the three-trimester ruling of Roe v. Wade was an undue burden test that Justice O'Connor added in the plurality opinion. And as has been noted, and as is noted in this draft opinion, no one really knows what that means. What is an undue burden? What is a due burden? And that was what Justice Scalia in the concurrence of that opinion said, you know, what does that mean, an undue burden? And so there wasn't a lot of clarity. And, you know, if it was a substantial block to a woman being able to get a right to an abortion, then it was an unconstitutionally undue burden on the right to have an abortion. So Alito is addressing the ruling and reasoning of Planned Parenthood as well, and noting that the reasoning there was fuzzy and incomplete. What brings this case before the Supreme Court today is a Mississippi law that states that no abortion except for a medical reason or death is allowed once the fetus has reached 15 weeks. So that is the law that is being challenged, that the court is addressing in the draft opinion here. And on page 5 is where Alito gives the bombshell language. We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in the nation's history and tradition. So remember, we mentioned that in the first paragraph, that that was a telegraph of what's coming. And implicit in the concept of ordered liberty. The right to abortion does not fall within this category. So that is the bold ruling right out the gate that Justice Alito is making in this draft majority opinion. Concerning Roe v. Wade, he says, Roe was egregiously wrong from the start. Its reasoning was exceptionally weak and the decision had damaging consequences. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. So, want to make sure that this is a clear point. This case does not ban abortion. It simply notes that there is no constitutional right to it and leaves it to the states to determine. It leaves it to the people to vote in what position they would hold on the issue of abortion. So, in other words, politicians now no longer get to hide behind the Supreme Court on this issue. They now have to campaign and argue as to how the states should do things, and or even how Congress should do things. Previously, they've been able to hide behind the court and say, well, the court's made the decision, so we just got to do that, and they've been able to hide behind that. But now the elected representatives on both sides will now have to sway the minds and hearts of the people regarding abortion. So abortion is still allowed. It's just not a constitutional right such that the states are not able to address the issue by elections. And that's what Alito is pointing out here. 2 times in the opinion, Alito addresses the government's position, and it says, they tell us that no half measures are available. We must either reaffirm or overrule Roe and Casey. So it almost sounded like they were trying to give them an opportunity to find some way to make it work. But since the government was so adamant that they either have to affirm in whole or overturn in whole, Alito's bringing this up and saying, hey, you asked for it. You said one or the other, so this is what we got to do. And he says that twice in this opinion, so I thought that was interesting. The question, the issue that the court is seeking to answer that they granted certiorari for was to resolve the question whether all pre-viability prohibitions on elective abortions are unconstitutional. So they're granting the question not just for the 15 weeks issue, but all pre-viability abortions. Should they all be prohibited because they are constitutionally protected? So this will go beyond just the Mississippi ruling to include any abortions, and that is why they're overruling Roe and Casey in its entirety. And the court explains why. Alito begins the argument by saying that Casey did not address an issue that this court is going to address, and that is the history of abortion law prior to the enactment of the 14th Amendment. First, the Constitution is the thing that they have to look at to begin with. It says the constitutional analysis must begin with the language of the instrument, which offers a fixed standard for ascertaining what our founding documents meant. So in other words, they look at the plain language. Is it in the Constitution? The Constitution makes no express reference to a right to obtain an abortion. So Roe held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned in the Constitution, in that they rely in some penumbra, some mixture of the 1st, 4th, 5th, 9th, and 14th Amendments. According to Alito, Roe had a feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution, and that specifying its exact location was not of paramount importance. So in other words, they're saying, look, there's a right to abortion. We don't see it in there, but it's got to be in there somewhere. And the fact that it's not explicitly mentioned or we can't really find it doesn't mean it's not there. That was the reasoning, according to Alito, for the Roe opinion. Alito also addresses the issue of the Equal Protection Clause, and he notes neither Roe nor Casey saw fit to invoke this theory of equal protection under the law, and it is squarely foreclosed by our precedents, which establish that a state's regulation of abortion is not a sex-based classification and is thus not subject to heightened scrutiny that applies to such classifications. In other words, the Equal Protection Clause does not come into play in the issue of abortion. Because there is no express language in the Constitution regarding the right to abortion, the next step is it implicit through some mechanism in the Constitution? And that's what Casey, Planned Parenthood versus Casey, argued. Casey's bold assertion that the abortion right is an aspect of the liberty protected by the Due Process Clause of the 14th Amendment. And then Alito goes to explain Due Process Clause protects two categories of substantive rights. The first consists of rights guaranteed by the first 8 amendments. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. The court has long asked, in order to find this to be a right that is protected, an implicit right, whether the right is deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty. He then goes through several cases where it has been determined that the burden has been met to show that it was implicit in the nation's history, deeply rooted, and that it was an important part of the ordered scheme of liberty, including Justice Ginsburg's opinion that relates all the way back to the Magna Carta and Blackstone commentaries. And then there's another case where it involves the Second Amendment, where they go all the way back to the legislative debates regarding the Second Amendment. And then he also explains one when it comes to the right to assisted suicide in Washington versus Glucksberg that found that it did not meet the test of being within the ordered scheme of liberty and deeply rooted in history. And the reasoning behind these parameters is that we, as a policy in the United States, do not want the court to engage in judicial activism. We want the people and their representatives making and enacting laws. We don't want courts to do that. And that's what he's saying here. It has sometimes led the court to usurp authority that the Constitution entrusts to the people's elected representatives. We don't want elected representatives to be able to hide behind the court. We want them to be able to go out and argue and campaign and persuade American minds to be able to vote a certain way. Whereas if the court engages in judicial activism, it takes away from the people as well as the representatives the rights and responsibilities to engage in an ordered society. So what Alito then says is we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. So this is where he goes into the history behind abortion. He says on page 15 of the draft opinion, until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero, none. Those are his words. I've never seen an opinion that included zero, none. But we have it here now. He says, not only was there no support for such a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences. And in fact, at the end of the opinion, I believe it's near the 60s. It's a pretty long opinion. It's very detailed. Yeah, so on page 68 through the remainder of the opinion, there's an appendix. It's Appendix A, and it includes all of the statutes criminalizing abortion at all stages of pregnancy in the states existing in 1868. So this is all the different states that had those abortion criminalized laws in place at the time of the enactment of the 14th Amendment. And so he's pointing that out in all of those different states to show that this was not part of the ordered scheme of liberty and deeply rooted in our nation's history. Alito notes that even when Roe was decided, 30 states, a substantial majority, all prohibited abortion at all stages except to save the life of the mother. The court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history or tradition of our people. So he's saying even with Roe's reasoning, they acknowledge that it was not deeply rooted in our nation's history. On page 31 of the opinion, Alito writes, ordered liberty sets limits and defines the boundary between competing interests. So in other words, liberty isn't open-ended to whatever anybody wants. We all have liberty to an extent, but it's not boundless. It is not boundaryless. And it says at the bottom of that paragraph, our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. So in other words, the people can decide to enact laws that allow abortion. They can enact laws that ban abortion. It is up to the people to decide. It is not up to the court to usurp that authority. And that's what he's saying in the opinion. This does not end abortion. There will still be states that will enact laws that will allow it. Now, there will be consequences to that, and we'll deal with that probably later on. But I just want to make sure we are understanding what the opinion is saying, is that it does not end abortion per se. It's not a ban of abortion. It simply is not a constitutional right. To show that this should go to representatives and votes of the people, he notes the two sides of the argument and notes that, there are women's advocacy groups that say that, the right to a woman's body should be able to, she should be able to choose to do what she wants to do. But even in Roe and in Casey, they noted that that would be at the expense of a life or a potential life. So there's balancing interests between the unborn person and the woman who is giving birth to that person, and there's competing interests there. So the side on the fetus side says they note that attitudes about the pregnancy of unmarried women have changed drastically, that federal and state laws ban discrimination on the basis of pregnancy, that leave for pregnancy and childbirth are now guaranteed by law in many cases, costs of medical care associated with pregnancy are covered by insurance or government assistance. The states have increasingly adopted safe haven laws. So these are competing interests, and it's not for the court to balance out those interests. That is for the elected representatives and the votes of the people. Of course, the primary argument that Casey relies on is stare decisis, because while they said, well, Roe's reasoning wasn't great, but because the court has decided that there's a fundamental right to abortion, we're going to uphold that based on the principle of stare decisis. So Alito is going to attack the issue of stare decisis and why they should not follow the opinions of Roe and Casey. Alito notes that no justice of this court has ever argued that the court should never overrule a constitutional decision, but overruling a precedent is a serious matter. There are 5 factors that strongly weigh in favor of overruling Roe and Casey: the nature of their error, the quality of their reasoning, the workability of the rules they imposed on the country, their disruptive effect on other areas of the law, and the absence of concrete reliance. And then he goes through and explains how each of those 5 factors weigh in favor of overruling the stare decisis holdings of Roe and Casey. In regard to the nature of the court's error, Alito says that the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. So that's the nature of the error. The quality of the reasoning says Roe found that the Constitution implicitly conferred a right to obtain an abortion, but failed to ground its decision in text, history, or precedent. In regard to workability, the 3-trimester scheme of Roe was not workable, and especially with the Jane v. Doe. And as to Planned Parenthood versus Casey, the undue burden test didn't make any sense, according to Alito, in his opinion. So it showed that the opinions were not workable. In regard to its effects on other areas of law, he said that Roe and Casey have led to the distortion of many important but unrelated legal doctrines. And that effect provides further support for overruling those decisions. Members of this court have repeatedly lamented that no legal rule or doctrine is safe from ad hoc nullification by the court when occasion for its application arises in a case involving state regulation of abortion. So they essentially argue that the effects on other areas of the law, because of the ability of the court to just be able to usurp everything that the legislatures want to do, causes problems in other areas of law, because what stops the court from being able to do that in other areas? And then the reliance interests, they argue that there's no reason why reliance would prevent an overruling of Roe versus Casey. It says traditional reliance interests arise when advanced planning of great precision is most obviously a necessity. In Casey, the controlling opinion conceded that those traditional reliance interests were not implicated because getting an abortion is generally unplanned activity, and reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. So even Casey noted that there was no reliance interest in requiring them to follow previous precedent. And essentially Alito's sticking that in their face and saying, you can't argue above what you've previously said. There is no reliance interest. But even beyond that, it says the controlling opinion in Casey perceived a more intangible form of reliance. It wrote that people had organized intimate relationships and made choices that defined their views of themselves and their place in society in reliance on the ability of abortion in the availability of abortion in the event that contraception should fail, and that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Essentially, they're saying that that women are out there being able to rely on this to be able to live how they want to live, to make their social choices, and that because of that, they're able to have more control over their bodies. On page 61, it says, our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. So Alito is kicking everything back to the people and to the elected representatives and say, if this is something that you believe should happen, convince the people. Convince the people. Win elections. Elections have consequences. That's what he's arguing here in this opinion. On page 63, Alito says, our sole authority is to exercise judgment, which is to say, the authority to judge what the law means and how it should apply to the case at hand. The court has no authority to decree that an erroneous precedent is permanently exempt from evaluation under traditional stare decisis principles. Roe did not succeed in ending division on the issue of abortion. Neither decision has ended debate over the issue of a constitutional right to obtain an abortion. On page 65, Alito says, we do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. So that's the decision that Alito is allegedly sending out in this draft opinion. So what happens now? What happens if a state enacts abortion legislation? Well, instead of it being a fundamentally protected right subject to strict scrutiny or this undue burden test or whatever test we're using these days, they now are going to be using what's called the rational basis test. Rational basis review is the appropriate standard for such challenges. The states may regulate abortion for legitimate reasons, and when such regulations are challenged, the Constitution cannot substitute, the courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. In other words, the law must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. And that is the lowest constitutional standard. The highest is strict scrutiny. The middle is intermediate scrutiny, and there's a couple of different versions of that. Significant and important, substantial, and other things of that nature. So those are important. And then the lowest constitutional standard is the rational basis test. And that is what is being applied. So Mississippi's law is upheld because it serves a legitimate state interest in protecting the life of the unborn, and it's rationally related to achieve that end. So that is the law regarding abortion. So what are the consequences of that? Well, number one, if this opinion does become the law of the land, it's going to send everything back to the states to determine what the issue is, what they want to enact in regard to abortion. So that means that the elected officials will need to represent the interests of the people. The majority will rule in whatever that is. And so this does not do away with abortion. It simply allows states to make the determinations regarding that through the votes of the people by its elected representatives. So that's the first thing. But the other thing is what about people who want to have an abortion and they live in a state? It may cause them to have to move to another state, and you may see that there's some movement. I don't know. I mean, obviously this is going to have more of an impact on those who are in poverty and lower income, because they're not going to be able to afford to move. So if they're in a state that doesn't allow abortion, then that's going to cause some problems for them. How much of a problem that's going to be, we don't know. The states will have to address that issue, and will have to make determinations based on votes and based on the will of the people through their elected representatives, and they'll have to campaign and argue those issues. So they can't. That's just how the states are going to have to do it. But the other thing is that now elected representatives aren't going to be able to hide what their opinions are, because there were always those elected officials that were in favor of abortion, but always said, well, personally, I don't agree with it. I don't agree with it, but, you know, the court's spoken and all that. Well, now we're going to see who the elected officials are that are in favor of it and who oppose it, because now they're going to have to put out their arguments and their reasoning as to why abortion should be allowed or why it shouldn't be allowed. And so we're going to get to see revealed who the elected officials are and what their rationales are for the positions that they take. So that'll be very eye-opening to see as well. So I hope you found this video helpful. If you did, please subscribe to the channel, like the video, hit the notification bell. Please put in the comments what you think. What do you think about the opinion? Do you think that this is going to end up becoming law? Do you think that if it does, it's going to cause a lot of problems? Are you in favor of it? Please put in the comments. Let me know. Try to keep them respectful. You know, we don't need any threatening or any harassment. This is a place for ideas. So, you know, I want to hear from you. So please put in your comments. I'll read as many as I can, and I try to respond to as many as I can. So hope you found this video helpful. Until next time, stay tuned.